Good morning, everyone, and welcome to the second in our series of IT Masterclass webinars developed specifically for in-house counsel. Thank you to all of you who are joining us, and I can see the number of participants. There's more joining as I'm speaking, so that's great too. I'm Helen Davenport, a partner in the commercial litigation team at Gowling, and I'll be chairing our session today on mitigating risks in the cloud. I'm joined by partner Jocelyn Paulley. Jocelyn heads up our IT team in the UK, and her specialist areas of expertise cover IT agreements, data protection, data centres and telecommunications. In terms of housekeeping before we begin, Jocelyn's very happy to take questions as we go, so please do put any questions that occur to you in the Q&A box, and we'll also pick up any remaining questions at the end of the session. I also confirm that the session will be recorded and available after the event, and it will be circulated to you as well. Those details covered, I'll hand over to Jocelyn.
Thanks very much. So the pandemic's really shown us how much we all rely on online services to live our lives in these days when physical contact and being out of the house is something of a challenge. We rely on being online to work, socialise, do our life admin. You can have webinars like this and attend your conferences. I can hold a work meeting. As lawyers, we can remotely sign legal documents. We can all do our online banking, order food, order our groceries. You can see your doctor, entertain the children with TV streaming, have your social life doing quizzes and parties, and even, as I discovered during lockdown, have a back consultation if you really need to remotely. The benefits of this system are clearly evident to all in our personal lives, and of course from the point of view of those enterprises providing those services. This isn't something that has suddenly happened. It's clearly been a growing trend for businesses to move their services online. There was actually some research out in May this year, so just at the beginning of the pandemic, where it suggested that last year was actually a key milestone for IT cloud services on the basis that at that point, enterprise spending on cloud infrastructure for the first time outstripped spending on your traditional data center hardware and software type services and hardware. But that's part of a growing trend. Even industries that are larger and more entrenched maybe in their ways, like banking, had been moving some of their core systems, those big mainframes that they run, increasingly online. And if you look at new parts of the banking industry, like the challenger banks, they operate entirely online, providing their services to their customers through the cloud without any high street presence at all. So this isn't something that has happened suddenly. The trend has clearly been going that way, to put more and more online within well-established industries and enterprise. And then of course the pandemic has accelerated that, as even those businesses that weren't connected directly with their customers through the internet have suddenly looked to set up e-commerce sites, have looked to enable click and collect facilities. Restaurants have let you book in and order your meals online to limit that face-to-face contact. We've seen more and more workload being pushed over the internet. Experts now think that by the end of 2020, as much as 67% of enterprise infrastructure will be delivered via cloud services, and about 82% of the entire workload will sit on the cloud. So from an enterprise point of view, there's clearly big advantages to using cloud in times like these, but also more generally to deliver services faster, more flexibly. They're relatively straightforward to set up compared to sort of traditional IT implementation, which would have maybe a long mobilization period and transition and testing. These services, you go online, click a few buttons, accept some terms and conditions, and then there you are up and running. They're quick to set up, and maybe most importantly, they require little or no CapEx spend. So departments looking to use online services can simply deploy their OpEx spend that they have access to for whatever they need that year without having to go and apply for specific funds. It's very easy for them to deploy. If businesses have taken up cloud services in such great volume or such enthusiasm, does that mean that the risks we were looking at maybe 5, 6, 7 years ago have all gone away? At that point, this was still quite a new technology. There was a fair amount of nervousness around using it and what does it mean. It was seen as quite a big step, put your systems and your data into the cloud. So now everyone is embracing it quite so enthusiastically. Does that mean that's changed? The answer, of course, is no. There are still risks there. But as we've become more familiar with the technology and how it works and how you mitigate them, then it's become easier and seen as a less risky approach for businesses to adopt cloud services. So given all this background and what's going on, we thought it was worth a session just to refresh on what those risks look like and how you might go about mitigating them in your contracts. But before we jump into what are the risks, I thought it was worth just a really brief slide on what do we mean by the cloud and what are cloud services. It's not a term of science. This is much more a term of art. Different people will give you different answers to the questions, what is the cloud? But you can break it down into some component parts. And it does mean as well that it's really important when someone in your business comes to you and says, we want to use some cloud services, that you do drill down with them to make sure both you and they understand exactly what you are buying, because the risks I'm going to talk about will vary in degree depending on what type of cloud the organisation wants to use. So broadly, what do we mean though? You're talking about servers running some software that's delivered remotely to you, usually over the internet, so a level of connectivity. Those servers though are clearly not directly located in the same building and place as you. They are remote. They are physical servers, just machines like you would normally have hardware running your applications on. Nowadays, though, they also are very clever and become virtual as well as being physical servers. So one real machine might be pretending to be 4 or 8 servers. They act as if they're more, and you might be accessing a part of that one physical server. We said those servers are remote, they're not sat with you, and so you get access to them through some kind of connectivity, usually just over the publicly available internet, so public infrastructure, although you might have, in some scenarios, some private connections, but it starts to look less like a cloud then if you're not receiving this over the internet. So that's sort of what the physical structure looks like, but then there are different ways in which it can be set up. And it's really important to establish which type of cloud you're going to be using for any particular service. Cloud in its truest sense is what we call a public cloud. So there is one instance of software which all customers have access to and use that same functionality, all running on the same piece of software. There might be bits you can tweak around that. If you think about Gmail, if you use it, you can set up your own folders, or you can have your own tailored background there. But fundamentally, you're all using the same functionality that the operator is maintaining in the same way for everyone who is using it. At the other end of the scale, you have what they call a private cloud. So there, the instance of the software that you are accessing is only ever going to be accessed by you. So there, it's a much more tailored environment. You have much more individual control because you're the only customer that the operator is supporting that infrastructure for. And depending how far you take that, it starts to almost drop out of cloud and become just a managed hosted service, more like in a traditional outsourcing world. And then you could have some kind of hybrid, either because you as an organization use both public and private clouds, or for any particular service, the way it's been structured, you're accessing part of a public cloud and part of a private cloud alongside it. Whatever sort of cloud you're using, it's really important to remember that this isn't a provider that you're engaging with to receive that service. You think of it as a technology stack where at the bottom you've got a data center with some physical infrastructure, the space, the power and the cooling. Someone comes along and puts their servers into it, might give you an infrastructure as a service where they have that raw compute power sat there for you to then deploy onto. Or they might provide a platform as a service. So you've got a Microsoft Windows operating level or Linux, whatever environment you're in. Or you might be contracting at the top of that stack to get access to an application for particular functionality that's sat on someone's platform or someone's infrastructure in someone's data center. So depending on where you're contracting in that stack, you might actually be touching a range of providers' services to get the thing that you actually want, the functionality you're looking for. And I put this as also an increasingly complex environment, not not just because of that stack, but because if you think about a traditional IT range of suppliers, there would have been lots of those, absolutely, for all the different software and hardware elements that an organisation's using, everyone who's supporting those, your implementers, your integrators, and everyone who supports. And the cloud world is just the same. Thales did some research and they say that 4 out of 5 companies actually have 2 or more of those infrastructure as a service or platform as a service providers, so sort of at the lowest level in the stack. The vast majority, so about 86%, have more than 11 SaaS providers, so at the highest level, and about a third of companies have 50 or more SaaS providers. That's a huge number of providers that you're engaging with, and particularly complex when you then think that at that highest SaaS level, there is a whole stack of providers beneath them that are ultimately enabling the service that you're receiving. I'm also saying it's complex because we've seen the growth of what's called shadow IT. So that's the idea that because these cloud services are so easy to deploy and contract for, and departments are just using their OPEX they have in their pockets, so to speak, pre-approved spend, they're just going out and contracting for bits of these services, and they're being deployed and not controlled centrally by the IT function. So an organisation's central IT doesn't necessarily have a hand on all these extra bits of cloud services that might be being used by departments. Not something wrong with their use, but it's the fact that that's invisible to the organisation. So particularly thinking about it from a data angle, you don't have a handle on all the third parties who might be touching or seeing your data. So that starts to create extra risk and complexity there. So we're going to look at in this session, what are the risks in using cloud services? I'm going to look at risks specifically for cloud, so there are different risks to just using software or even using a traditional outsourced supplier. But the degree of those risks and quite how you mitigate them will vary depending on whether you are using a public or private cloud, which is why it's so important at the start of any engagement to understand exactly what type of service you're using so you can correctly assess the risks that might occur. The first one I'm going to look at is the one I think that comes to most people's minds when you start to talk about cloud, cybersecurity. That term in itself covers quite a range of risks. I think we're talking about everything from security standards, so the cloud provider's own policy or the sort of industry recognised standard they might be following. We're thinking about external threats, so malicious targeted attacks on particular enterprises or particular cloud providers. And obviously we are seeing increasingly sophisticated natures of those attacks in the way that they are working themselves into organisations. Thinking about viruses that occur in very commonly used software, you think about WannaCry and issues in SQL databases that are embedded in just so many software processes. They pose a risk, particularly where you as an organisation aren't familiar with the precise bits of software that might be being used to provide a service to you. And also if you're using a cloud service provider, that in itself just might make it a more tempting target for anyone looking to cause mischief. As rather than having to go through lots of effort to target maybe 100 companies, a cyber criminal can just go straight to a cloud provider, and therefore their chaos will kind of be multiplied across that entire cloud provider's customer base. So what can we do around cybersecurity to make ourselves feel more secure and reassured? Well, the very fact of using a cloud service provider is mitigation in itself to some extent. Think about it, your enterprises, your reason of being and your mission in life is to deliver your services to customers, whatever that might be, food or clothing or banking or telecoms. You're not experts in cybersecurity as a speciality in itself, whereas the cloud provider, security is one of the fundamental things that they are providing to clients. So they are actually arguably in a better position to be bang up to date with what the latest threats are and the best way to address them. It is important to establish what that level of security is, and you do sometimes see a bit of a tussle between the customer's security policy and the supplier's security policy and working out whose is going to apply. Usually though, and definitely in a public environment, because this is what the operator provides for all of its customers, it will be a case of the customer's security team taking the operator's policy, working through it to see that they're comfortable it provides sufficient level of security for the nature of data or the type of service that you're looking to procure, and then contracting on that basis. And it is important to make sure the contract does clearly reference and incorporate whoever security policy you agree between you is going to apply. You do see in some cloud service contracts some very woolly references to security, but from a legal point of view, you want certainty of knowing what that policy is and what it says and where it can be found. There is a bit of a trade-off here, and you do have to be careful not to tie it down too tightly. As lawyers, obviously, we like certainty, but cybersecurity is not something that's static. There are new risks emerging all the time as the cyber criminals become more inventive or find new flaws, and therefore security practices obviously update to work out how to address and mitigate those technical risks. So whilst you want the certainty in your contract of knowing what the security measures are, you need to include language to allow those measures to improve and build over time. The language talking about the policy changing, but not providing a lesser level of support than you contracted for on day one. And you probably want an assurance that that security will always comply with good industry practice as well, to allow the supplier to do what they do best and actually keep improving the security measures that are applied to those services. You can look at different levels of security as well. We see in some cloud contracts that security actually becomes linked to payments and charging, because some suppliers can offer different levels of security for particular environments, and that's a service for which the customer pays. So that's always a question to ask to understand, can you enhance security if you think the basic level that's being offered isn't sufficient? Understanding that probably comes with a charging consequence. We have seen this though get really quite tricky, where the cloud provider and the customer have had different views on what an appropriate level of security might be in a data protection context. So the cloud operator was actually uncomfortable with their GDPR obligation to provide appropriate security, because they were being told by the customer, on the other hand, that the customer only wanted to pay for this level of security, whereas the cloud operator thought it should be this level, given the nature of the personal data that was going to be in that cloud. And that was a charging point issue between the two sides that we had to resolve, whilst making sure that GDPR obligations were also fulfilled. But you can also think about additional levels of security from a customer side in terms of additional things you can put around the cloud or things you can control within your own environment that might bolster the security provided by the cloud operator. No matter what security measures you agree to put in place, it is critical that as a customer you are notified if there are any breaches or are any issues. Clearly, it will be the operator's responsibility to work out what's gone wrong and to put it right, but you need to know so that you can have influence over other things, so press releases and the public relations side of any breach, and obviously communicating to your customers to let them know what's happened, what's being done about it, and to make sure they are reassured that they're not at any risk, or if they are, what they can do about it. So you can only be in that position if you have provisions requiring the operator to let you know what's happened, to keep you updated, to make sure that you can then talk to the public and to your customers. Your IT department might normally want to do things like penetration tests on any providers that they engage with, so that you get some first-hand assurance that the security has actually been put in place, and to see how robust it is. For cloud providers though, that can be quite a challenge if their entire customer base is doing friendly attacks on their environment, and that creates a risk in itself. So it's really important to understand whether or not your provider would allow this, or if you need particular permissions to do that. We have seen separate penetration testing agreements and permissions, so the cloud provider is aware the customer is going to do it, and the customer is free to do that without the provider thinking they are actually being attacked and pushing them out and shutting them down. Or you might find the cloud provider arranges its own penetration tests and then issues some kind of report to its customers to show them what the outcome was and prove the level of robustness of its security. The similar issue around audits, customers would often want to go out and audit a security setup in a physical on-site way, or by doing some active testing, or just by issuing due diligence questionnaires. Again, though, for a cloud provider who's offering an infrastructure across a very large number of customers, that can be prohibitive and would mean they were just being audited on every single day of the year by one customer or another. So more typically, and particularly the hyperscalers, they will engage their own independent third-party auditor who would then audit and issue the report for the benefit of all customers, so they have that comfort over the level of security and rigour that's being applied, but without having to do that audit individually themselves. Insurance is an obvious topic that springs to mind in terms of cybersecurity. What cyber insurance does the operator have? That is a whole topic in itself, which is why we have a separate IT masterclass session on insurance, so I shan't say much more about that. I will briefly say, though, encryption, because that is the other word that springs to mind when people suddenly start to talk about security. It's one of the measures that the cloud operator might use in terms of securing their system. But again, it's a detailed question. Certainly not all types of encryption are equal. There's weak and there's strong encryption. You might be encrypting data in transit or static data once it's being stored. And there are different cost implications to applying different levels of encryption as well. So again, you can't just either presume that a cloud operator encrypts data when it's moving around or once within their environment. And it might actually not be necessary or might not be the best way of protecting that data. The next one I want to talk about is the lack of physical control. So whereas in a traditional outsourcing, you might be allowing your outsourced provider to have access to all your systems and all your data, often those systems will still be within your own physical control. You won't have a third party necessarily running it for you. Whereas here, you've actually given over that physical access to a third party. The servers on which it's running, they're not on your sites or even in sites that you control. And the servers themselves are not owned by you, it's all third-party owned, third-party controlled, so it can feel like that data is very remote and out of your control. The way you can make yourself feel more in touch with that is by making sure that you do have access rights to go and access the data centres where that data is being held. So making sure within the contracts that you know and you have rights to go and access your space within the data center. Sometimes customers actually site engineers within data centers with the benefit that then these are people who understand your specific systems rather than relying maybe on data center staff who service the entire data center and all the customers who might be sited there. Obviously, pre-contract due diligence visits to understand the nature of the facility in which the data will be housed and what physical security there is around those data centers, because often you will be one tenant or one customer within that environment, while there'll be many others who legitimately have a right to be there, and you'll want to see how that is controlled. You'll also want to know if when your own people go, are there pre-vetting procedures, do you need an induction, all those kind of issues, so that when an issue does arise and you need quick access, you know how you're going to do that. Reporting and audit rights, similarly, you can ask for that around the physical control and access measures. But again, because of the shared nature of the infrastructure, it's unlikely a cloud provider will want all customers to be able to regularly come and physically audit them. But I think, maybe it's because I'm a lawyer, but one of the biggest comforts here is that we do have some helpful law on the relationship between physical control and the data. So I think there is a misconception that's maybe widely held that data is owned by a company. If it's data about your customers, your systems, your finances, there's a legal right of ownership. And that's not the case. Data is not like intellectual property where there's a legal title and a legal beneficial title to the intellectual property around creations. You don't have that same proprietary right in data itself. And if you think about it, that must be right, because otherwise all the facts about the world and the way it works would have to be owned by someone, and then there'd have to be some kind of structure to allow others to access and use it, and that doesn't exist. And it isn't just lawyers extrapolating concepts, there is actually some case law. A case from 1979 found that information was not property and couldn't be stolen under the Theft Act. And then more recently, from 2014, the Court of Appeal, so an even higher authority, found that you could not exercise a lien over a database. So a service provider which hadn't been paid by its customer was holding on to its customer's database and saying, well, we're going to hold this as a lien until you pay us. And the court said, a lien is a proprietary right, you cannot exercise that over data. And that's helpful in this scenario because it gives a little more comfort. Although someone else is physically holding and controlling your data, they can't use that as some kind of hold over you. So, well, we've got your data and therefore that puts us in a strong position against you, the customer, whose data it is. Having said that, though, do watch the contractual provisions because you will typically see clauses that say that unless the provider has been paid in full, the customer won't be able to get data back maybe at the end of the contract, or there's a suspension right if payments are not paid on time, because that is, of course, the biggest stick that a provider has over its customer. So whilst the law is comforting, watch the contractual terms that go into contracts for cloud services. Alongside the lack of physical control, you also want to think about geographically, where is my data going to reside in the world? It's clear if it was in your basement or one of your properties, you'd know where it was. With a cloud service, it could be located anywhere in the world, even if you're contracting with an English-based company. So you want to work out where the data is going to be, and from that you then need to think about, are there any local laws that might apply that mean that governments or law enforcement agencies have local mandatory rights to access that data? Are you comfortable with that risk given the nature of the data you might be putting into that cloud service? You'd also want to think about enforceability. If something went wrong and you had to go to the extent of getting an English court judgment, how easy would it be to go and enforce that judgment, particularly if you're thinking about access to your data? There is an issue with you and your provider and you eventually have an order saying your data has to be handed over, you want to know that that order will be enforced in the jurisdiction in which your data is residing. You also need to identify if you have international transfers from a data protection point of view to make sure you put the right measures in place. So although the data could be located anywhere, you can look to contractually limit where it's located. The big providers, Azure and AWS, they let you nominate a region of data centers in which your data will reside. So not necessarily just one facility, but a number of facilities within a region. And there are very good reasons why they want that flexibility due to the way their systems are structured for their own resilience and load balancing. But you get the comfort as a customer that you have some level of certainty over where the data is going to go, and therefore you can assess those risks about local law access and enforceability. Obviously, there's a range of legal due diligence to do there to establish that and think about those things before you enter into the contract, because once you're in it, it will then be very hard, if not impossible, to say, actually, I don't want my data going to that particular location if that is the way the service provider is set up to provide their services. And obviously, from a GDPR point of view, you need to know where the data is to establish, is this an international transfer, and then have discussions with the provider about what safeguards and adequacy measures they put in place to do that in a compliant fashion. Following Schrems 2, obviously transfers under standard contractual clauses, particularly to the US, have become a little more complicated. So you need to make sure your cloud providers are responding to that and dealing with those issues. And in the contracts that we've seen being negotiated since the judgment in July and now, although providers haven't always quite got to the point of updating their terms before they are issued, when we've asked the question, we have received positive responses that they are looking to either bolster their standard contractual clauses or look at getting binding corporate rules approved or using other mechanisms. So if you have your data sat physically with another provider in another location, you might be more worried about confidentiality breaches and feel there is greater potential for there to be a breach because that your data is sat and residing within a third party, within their infrastructure. So there is greater potential in the course of transferring that data between you and provider and that remote access. That could be misused, abused, or data could be intercepted when traveling between the two parties. Or you might see a risk in the fact that the cloud service provider's own employees can access that environment probably quite properly for support and maintenance activities or fixing issues when they arise, but that might seem like a point of weakness in the structure. So to deal with that, I think this is largely a legal and contractual response. There are some more practical measures. As a client, you can make sure that you maintain admin access rights. So you at least have the right to appoint who else has access, and you can see within the provider who their super users are for break fix and support roles. And you could then have access to the access logs, so you know who's been in and out of systems at what time. There may be other practical measures that in a particular scenario you want to put in place for the nature of the system that you're procuring, but you certainly want to make sure that contractually you have really clear confidentiality clauses that specify that all the material and data that you put into the system, that's generated through the use of the system, that the supplier can access in the course of providing services, all of that has a label of confidentiality over it, and that the provider can't do anything else with it other than provide the services to you. The interesting development we're seeing here is providers pushing the boundaries of what they can do with that data that resides within their environments, particularly starting talking about how they might want to reuse that data in an anonymised, aggregated way in order to commercialise the data that's sat within their environment. So typically a provider might be providing services to customers in a particular sector. They're aware they're sat on a huge volume of data that relates to the particular sector. And if they could conduct some analysis over that, they could spot trends, look for issues, they might be able to gain some insights which they could then play back to the industry, possibly on a commercial basis, and generate money from all that data that's residing within their environments. And I've had clients come to us saying, I've become alive to the fact the provider is either doing this or wants to do it, and can they do that under the terms of the contract? Certainly older contracts barely ever had clauses in saying clearly either positively or negatively that providers could do this. Increasingly, we are seeing cloud provider standard terms give them permission to do this, so it's clearly stated. But in the absence of any clause saying either way, you do fall back on the confidentiality clause. But the providers run the argument that, well, if I'm using the data in a way that doesn't identify you, Mr. Customer A, then how is that going to cause any harm to you? And so how would you ever bring a claim against me for breach of confidence, because there's no harm being caused? So it is something of a grey area unless you have a clause that specifically states one way or the other. And certainly if we are acting on these, we would put in a clause and talk about the issue with clients so you can determine whether or not you are comfortable with that risk or certainty, depending on what the cloud provider's terms say. Exit is an interesting one to talk about in terms of cloud services. Here your data is all sat with that external provider. So there's a risk around getting that data back within your own environment, which is different from all the other risks we usually think about in terms of a smooth handover and knowledge transfer. You want to watch to ensure that the provider is not going to automatically delete any of your data when the contract comes to an end. You need to work out how you're going to get that data back from the provider and get it back in a format that is something that you can use again, that will be compatible with other environments. And that's why this term vendor lock-in becomes relevant, because it might be that the vendor has ended up structuring your data in a particular way that it's either hard to extract, or it's expensive to extract, or it's expensive to reformat into a form that you could actually use again within your own organisation or with a future provider. So as with anything, you need to think about this from the start, not just at the point of exit. It's worth finding out from your provider if you can do what I've termed self-help. Can I help myself to copies of my data through the life of the contract, which you might want to do for business continuity reasons as well. But obviously means on exit, you're not reliant on the provider doing something for you. You can actually actively go in there and do it yourself. You can, of course, have classic exit assistance obligations to, if they do have to reformat that data, or they do have to actually provide it to you in a particular format. I would always suggest that you do state that format is something that has to be agreed between you, or it has to be in a specified file format, or something that's a common format like a CSV file. So you have that certainty, because we have seen disputes where customers are saying, my provider's saying I can have my data back, but it'll cost me X because I have to reformat it out of their own systems and into something else, and that's a costly exercise. It's always better to be clear up front how that's going to work. We often get questions about, can data be put in escrow? That's obviously a business continuity risk, but also potentially useful on exit. You do now see the classic escrow providers, so the likes of NCC and Iron Mountain, do offer data in escrow services. So it exists. The question, of course, is it appropriate for the type of service that I'm running? Because if this is a real-time system where data changes every day or minute by minute even, then holding data in escrow is going to be of limited value if that's data from a week last Monday, but there's been 10 days since and a huge amount of data would have changed. So getting yourself back to that point would still be a really expensive exercise. But if this is maybe a reporting system where actually you run a report once a month using the cloud service, it might make sense then to take that snapshot of data, put that in escrow, and then you've got it there if something goes wrong in the next month. So it all comes down to context. This idea of vendor lock-in, I think you can address in a couple of ways. Sometimes the issue is that there is some vendor IP ends up being inextricably bound in with the data in the way that they formatted it or set it up in a database, or the way they're using it within their systems. And they say, well, you can't just give it like that to someone else, because that will give a competitor an insight into how we run our systems, and they're uncomfortable with that. So making sure you understand how they're using the data in the life of the contract, and then the format in which you will then get it back. And also I put this idea of service manuals. So if you're going to appoint a new cloud provider, do you need to know how, in a process kind of sense, your existing provider has been running a service? If you've taken the view as an organisation that you just wanted to buy a vanilla cloud service and you were actually going to reshape your own internal processes, or maybe processes that are customer facing, to match how a particular cloud service provider provided a service in a process sense, it might then be really important to have some kind of manual written down of how that is done, to give to a new cloud provider to say, this is how it happened before, this is what our customers see, what we expect to happen, so you have that continuity from one provider to another. So I've mentioned business continuity a couple of times there in the course of talking about exit, and this is a topic in its own right to think about. The risks here are that, again, your data is physically sat with someone else. So what happens if they suffer some kind of disaster separately to you? What happens if just that connection between you and them goes down and you can't get the access to your data because you can't call for it at that point in time? So do you understand what the plan is? Because unlike a traditional outsourcing where you would expect your provider to create a business continuity plan, possibly bespoke, specific for you in the particular service they're providing, here in a shared infrastructure environment, that is highly unlikely to be the case, because the provider is runs one system for all its customers. So you need to work out what is the plan, how might it fit with your plan, and think about it both in the sense of the system and the service that's being providing and the data that's within that environment, depending on whether or not this cloud service is the sole repository of your data, or whether actually it's pulled from other sources that you hold and control centrally. So access to the data itself is not such an issue. So in terms of mitigations, you might see it as a mitigation in itself that you are using a cloud provider, because then if your organisation in location A suffers some kind of disaster, that might not apply to your provider in location B. That in itself might actually be a benefit rather than a risk. You do need to work out who is responsible for business continuity. Some cloud services offer a level of business continuity as part of their whole service package, or some might have it optionally as a chargeable service, or some might not offer it at all. But rarely when you look at a cloud service contract, do you see it called out as a clause heading like you would do in an outsourcing contract, and very rarely see it in any kind of service description or standard documentation. So you've got to ask the question to understand what the position is. and what the provider will be able to do. In the way that particularly the bigger providers offer these services, some level of business continuity is just part of what they offer, because they have such a large number and range and structure of other data centers. They do geo-replicate systems. The whole point there is resilience. So they have an issue at one location, they can shut it down and bring your system up somewhere else. But you need to understand, is that something your provider offers? Is it within their technical capability and structure, or is it something I'm paying for extra? Or as a customer, would it be up to you to know that if this provider fails, actually I've got another copy of my data somewhere else, or I have done that self-help and taken a copy of the data myself, so I could run some other manual process or something as an interim measure whilst my provider deals with whatever their issue is. And finally, the supply chain issue. So I talked at the start about how with SaaS, PaaS, IaaS, you have a contract stack. There is a whole chain of suppliers who are actually providing the service to you. But particularly if you're contracting for the SaaS, the software as a service, that chain is not very transparent. It's not clear how many subcontractors are involved and who they're using. There's probably either the contract silent or subcontracting, or it says that the provider can use whoever they need to subcontract any of their obligations. But it is important to understand who is in that stack so that you can assess all the things you'd want to in any procurement with a provider you're entering a contract with for anything material, looking at financial stability so you can be alert to any insolvency risks, and also as and when breaches occur, knowing who you should be talking to and whose responsibility it might have been to provide a particular bit of a service. So there's, at the start of the process, there's certainly an element of due diligence to ask these questions and make sure that you understand from the beginning who's involved, which organisations are providing this overall service to you. You can try asking during the life of the contract if there are changes to those subcontractors, that those are notified to you. Very, very unlikely that you'll be able to say, I want to give my consent to that, because again, your operator's providing a shared infrastructure. They can't have all their customers having a right to consent for who they use as subcontractors. You could think though, and this very much depends on whether you're using a public or a private cloud, whether it's appropriate for at the end of the contract, you could ask for novation of those any subcontracts to you. That's only going to work in a scenario where your cloud provider or your SaaS has actually gone off and contracted something that is more specifically for you. But we have seen that maybe where you're working with smaller organisations, that to provide a level of business continuity and to take some risk away, you can ask that the subcontract is novated to you if the contract with your cloud provider comes to an end, so you have some level of assurance around business continuity. You also want to know who's in the chain to understand which other organisations have access to your data and are handling it, so that if there are insolvencies, which you see in the press, you'll know whether your service has ultimately been affected. If you think years back to when the 2E2 data centre went insolvent, I think a lot of people suddenly became aware that they were actually involved in the contract stack that a SaaS provider was relying on to provide a service, so customers didn't even know that they had an issue until that insolvency happened and the SaaS provider came saying, we now need to think about what we do about 2E2 because they've gone bust and actually your data was sat there. Sorry, you didn't know about that, Mr. Customer. It also helps with a technical understanding of who is doing what, particularly around issues like security. At different layers of that platform, we have different people being responsible for different parts of security. And if there has been a security breach, it's helpful as a customer to know who should actually be talking to, who was responsible for that part of the security service. We often see this supply chain issue come up in scenarios where we're engaging with large companies who are often system developers or integrators and are designing and building a service for a customer that's going to be run on a cloud infrastructure. And we ask the question, well, do you actually own this cloud infrastructure, or are you prime contractor, if you like, using another subcontractor? And you would be amazed at how often the people we're talking to at the prime contractor do not know the answer to that question, and then it takes them quite a while to come back with the answer. And then when they do, they say, oh yeah, actually, there's these Azure or AWS terms that we need to try and shove into our contract as a schedule, which then obviously conflict with the front end terms, have different limits of liability, have different exclusions, and it ends up being quite a mess. And in some transactions has caused a significant delay to what we thought was something that was nearly closed, because of the length of time it's taken that prime contractor to come back with the answer to the question. So again, it's something I would always ask really early on to understand, are you, my prime contractor, going to provide this to me under some kind of umbrella agreement you have with your big cloud providers, and which you might use for lots of customers? Or are you going to set up something specifically for me, in which case you might be trying to pass through any risks in your cloud service contract direct to me? I need to understand how that fits into my overall risk profile and how it fits with the rest of my contract. So bringing all of that together, it is so important at the start of any of these procurements to understand the full context. Can you just move the slide on, please? Understand the full context about what cloud is going to be involved in this procurement. Is it public? Is it private? Is it some kind of hybrid? And drill down into how does it work? Is it just one instance of software lots of people are using? Are we customizing it? Are we adding bits onto a base piece of software? How does that work? And then understanding the data and the service you're going to be receiving from that provider, the data you're going to be putting into their environment. How sensitive is it? Do we have other copies of it somewhere else? Are we always going to be able to get access to it? So you can then do this risk assessment to balance the benefits and the risks of using the system, and work out whether these are acceptable risks and what mitigations you might need to put in place. You are almost inevitably going to be dealing on vendor standard terms for a lot of these systems, because they will be specific to their setup. So it does mean they need reading very closely, because they will always be very supplier friendly, and you need to watch things like automatic deletion of data on exit, or suspension rights, or not saying anything about reusing your data in an anonymized form. And often, as increasingly with IT software contracts, these will be layered. You'll have some master terms, you'll have some product specific terms, you'll have some additional terms if you're in the UK or the US. So putting all that together needs really careful, close review. And I would always say just to ask questions. Supplier standard terms don't say some things deliberately because they want freedoms, or it's a negotiation point that they don't want to raise. So make sure you continue to ask questions so you can make sure that you're comfortable with all the risks and advise your business appropriately. And that's it. I've put together a list of the risks just on the final slide so you could see them all together. I am now very happy to take any questions. Helen.
We do have a little bit of time for questions. So if anyone has any additional questions you've not already raised, do use the Q&A box and send those through. But to start with one, so Jocelyn, you talked about earlier in the presentation the risk of cloud providers potentially wanting to use data for their own purposes. Got a question specifically around, are you seeing clients being able to negotiate commercial return on granting of rights to cloud providers to use their data for analytics or AI purposes?
That's a really good question. Something very topical, because something we're talking about with various clients in terms of commercializing data sets. I think specifically in a cloud environment here, I haven't seen a customer raise it with a cloud provider where you're just receiving a generic service, so say from Salesforce or someone like that. I haven't seen a customer manage to negotiate with them to say, if you are going to go off and do things with my data, I want a return on it. But I do think that's a much better conversation to be having than just to find out that they are doing it behind the scenes and commercializing it and you are missing out on it. So I definitely think it's a conversation to have, but no, I haven't seen anyone actually be able to do that as yet.
And actually, whilst we're on that topic, a related question. In your experience, how do your clients feel about terms allowing anonymized use of their data?
I think it's very sector specific and dependent on the nature of the data that's gone into the service. So some cloud providers would say, well, the benefit of our service is that actually we we learn things from every client we work with, we take that learning and knowledge, we put it back into our system and we improve. And that is in effect part of what you're paying for when you engage with their system. So in that kind of scenario, people are quite comfortable with it. But that's generally where it's known up front that the provider reuses sort of knowledge and expertise and data in that way. On the flip side, if it's not that kind of scenario and it's something that the provider wants to do more covertly, I think even if clients wouldn't have an issue with it if they knew that was going on, the fact that it was being done without their knowledge, I think can be more damaging to the relationship overall and create a feeling of nervousness. So I have seen a range of responses in different clients on that, but it does very much depend on sector and the type of data that you're dealing with.
Thank you, Jocelyn. And one question, I think, on a very different topic, and that might be the last question that we've got time to take. But this is around obviously changes to sub-processor, subcontractor changes to those provisions, and that is it appropriate for those changes to be placed on a website as opposed to proactively notifying customers?
In a GDPR sense, if you've given a general permission for a supplier to engage sub-processors, and it says in the contract that they'll notify you through notification on a website, then I think that would satisfy the criteria. So I think from a compliance point of view, that would tick the boxes. Proactive notification is probably something that the customer would prefer, and it depends, I think, on how the operator systems are set up, whether that's something they can do for customers or whether they use that website functionality, or if the website can then ping an automatic alert to a customer to say this has been updated. I think it does come back to whether you've given that general consent, because if you have, then it is possibly more up to the customer to make sure it knows what subcontractors are being used if that information is made available by the operator.
I was going to pick on the point you'd made earlier about visibility of that stack, I think. Okay, so I think I'm conscious of time, so I probably ought to bring us to a close now. First thing to say is thank you to Jocelyn for all of your insights, really helpful. Thank you to everyone for joining us. If there are any more questions, I'm sure that Jocelyn will be more than happy for you to reach out to her directly. And actually, as I'm speaking, there are a couple more questions that have come in as well. So we will try and pick those up and come back to you. The next IT masterclass is the one that Jocelyn mentioned during the course of the session. So it will be on cyber insurance and cyber security. That is on the 4th of November. I will be speaking at that session, and we'll also be joined by Susanna Fink, a legal director in our commercial litigation team, who is an insurance specialist. So if you can make it, please do sign up if you haven't already. Thank you again.